The red and blue lights flash behind you. You pull over, heart beating just a little faster than normal. The officer approaches your window, takes a brief pause, and then says something that instantly changes the entire situation. "I smell weed." In that moment, what started as a routine traffic stop can quickly turn into something far more serious, legally and personally. But here's the question. When a cop says, "I smell weed," do you actually have the right to refuse a search? Or does that statement automatically give them legal authority to go further? Let me know your answer in the comments below. According to official court records and long-standing law enforcement practices, the smell of marijuana has historically been treated as a key factor in establishing probable cause. Probable cause, under the Fourth Amendment, allows law enforcement officers to conduct searches without a warrant if they have a reasonable belief that a crime is being committed. For decades, courts across multiple jurisdictions have accepted an officer's claim of detecting the odor of marijuana as a sufficient basis for searching a vehicle. However, the legal landscape is no longer as straightforward as it once was. With the legalization and decriminalization of marijuana in several states, courts have begun to reconsider whether odor alone is enough to justify a search. According to appellate decisions in certain jurisdictions, the smell of marijuana may no longer automatically indicate illegal activity, especially where possession is permitted under specific conditions. The background context here is important. Historically, when marijuana was illegal nationwide, the presence of its odor was treated as clear evidence of criminal activity. Courts generally deferred to the officer's judgment in these cases. But as laws evolved, so did judicial scrutiny. Some courts have started to question whether relying solely on odor is consistent with modern legal standards. Now let's walk through how these situations typically unfold in real life. According to law enforcement procedures, when an officer claims to smell marijuana, they may begin asking questions, request consent to search the vehicle, or proceed with further investigation based on their observations. At this point, every word spoken by the driver becomes legally significant. One interpretation of the law is that officers are acting within their authority when they rely on sensory perception, including smell. Another perspective raised in court is that such claims are inherently subjective and difficult to verify, which raises concerns about potential overreach. Courts have acknowledged this tension, and in some cases, they have imposed limits on how far such claims can justify a search. This is where understanding your legal position becomes critical. In my legal analysis, individuals retain specific rights during these encounters, particularly under the Fourth and Fifth Amendments. The Fourth Amendment protects against unreasonable searches and seizures, while the Fifth Amendment protects against self-incrimination. Courts would likely examine whether these rights were clearly asserted and respected during the interaction. This is for informational purposes and not legal advice, but one of the most important things to understand is that not every police request is legally mandatory. There is a difference between complying with lawful orders and voluntarily giving up your rights. That distinction often becomes the central issue in court. A key turning point in many cases involves consent. If a driver agrees to a search, even casually, courts often consider that consent valid. However, if consent is clearly refused, the officer must rely on other legal justifications. This is where the first of the 5 legal moves comes into play, and it's one of the most important. The first move is simple but powerful. Clearly and calmly state, "I do not consent to any searches." According to legal precedent, this statement establishes that any search conducted afterward is not based on voluntary permission. One interpretation is that this shifts the burden entirely onto the officer to justify their actions under probable cause. Another perspective raised in court is that while officers may still proceed, the lack of consent becomes a critical factor in determining whether the search was lawful. From a real-world standpoint, many legal defenses begin with this exact moment. Courts frequently review whether consent was given and how clearly it was communicated. A calm, direct refusal removes ambiguity and creates a clear legal record. Supporters of current enforcement practices argue that officers need flexibility to respond to potential violations quickly. Critics argue that relying on subjective claims like odor can lead to inconsistent application of the law. In my professional opinion, both sides highlight the importance of clarity, both in legal standards and in how individuals respond during these encounters. So now think about this for a moment. If you were in that situation, would you stay calm enough to clearly say, "I do not consent"? Or do you think most people hesitate when the pressure is on? Be honest. Drop your answer in the comments below. As the interaction continues, What happens after you clearly refuse consent often determines how the situation unfolds. The officer may pause, observe more closely, or begin asking additional questions. And this is where the second legal move becomes critical. The second move is exercising your right to remain silent. After identifying yourself and providing required documents, you are not legally obligated to answer investigatory questions. In my legal analysis, this right comes directly from the Fifth Amendment, which protects individuals from self-incrimination. Courts would likely examine whether any statements made during the stop contributed to establishing probable cause. According to court records, many cases have turned not on physical evidence, but on what the driver said in the moment. Even casual statements, like explaining where you've been, what you've done, or trying to clear things up, can unintentionally create legal exposure. One interpretation is that officers use these questions to gather additional justification. Another perspective raised in court is that individuals often underestimate how their words can be used later. This is for informational purposes and not legal advice, but maintaining silence beyond basic identification is often recommended by legal professionals. A respectful response like, "I choose to remain silent," clearly communicates your position without escalating the situation. Now, it's important to understand what this does not mean. Remaining silent does not mean refusing lawful orders. If an officer instructs you to exit the vehicle or provide documentation, those are typically considered lawful commands. Courts distinguish between refusing to answer questions and failing to comply with lawful instructions. This brings us to the third legal move, which is about control and clarity. The third move is, do not provide inconsistent or unnecessary information. In many real-world cases, individuals start with one statement, then add more details under pressure, sometimes contradicting themselves without realizing it. Courts often review these inconsistencies closely. In my legal analysis, inconsistent statements can be used to justify further investigation or raise suspicion, even if there was no initial evidence of wrongdoing. According to appellate rulings, credibility becomes a key factor. If a driver appears unsure, changes their story, or over-explains, it can influence how the officer proceeds and how a court later interprets the interaction. On the other hand, a calm, consistent approach, providing only what is legally required, helps maintain a clear and defensible position. From a practical standpoint, this means keeping communication minimal, respectful, and consistent. There is no legal advantage in trying to talk your way out of a situation through unnecessary explanation. In fact, many legal experts argue that less is often more in these encounters. Supporters of this approach say it reinforces constitutional protections and prevents misunderstandings. Critics may argue that it can make interactions feel less cooperative. But courts have consistently upheld the right to remain silent and the importance of clear, voluntary consent. Now here's something to think about. When people get nervous, they tend to talk more, not less. So be honest. Do you think you'd be able to stay quiet under pressure? Or would you feel the urge to explain everything? Drop your answer in the comments below. The fourth legal move is knowing your rights regarding searches. Even if an officer claims they smell marijuana, this does not automatically give them the right to search your vehicle without consent or a warrant. In my legal analysis, the Fourth Amendment protects individuals from unreasonable searches and seizures. Courts would likely examine whether probable cause actually existed or if the officer's perception was enough to justify a search. According to official rulings, probable cause must be based on more than a mere odor. Context, behavior, and corroborating evidence all play a role. Here's the key. You can clearly state, politely but firmly, that you do not consent to a search. A statement such as, "I do not consent to any searches," can later be crucial if the case goes to court. This is for informational purposes and not legal advice, but documenting your non-consent verbally protects your rights, even if the officer proceeds. Real-world examples show that officers sometimes overstep, and courts consider whether the driver clearly expressed non-consent when evaluating evidence. The fifth and final legal move is about maintaining composure and documenting everything afterward. After the stop, write down every detail you remember: the officer's words, your responses, the sequence of events, and any unusual behavior. This record can be invaluable if legal action becomes necessary. In my legal analysis, detailed recollection supports your credibility, particularly in traffic stop cases where inconsistencies can be used against you. Courts often give significant weight to contemporaneous notes or recordings. From a practical perspective, these 5 legal moves, refusing unnecessary consent, remaining silent beyond required identification, staying consistent, asserting your right to refuse a search, and documenting everything, together create a strong foundation to protect your rights during any traffic stop. Supporters argue this approach upholds constitutional protections, while critics may claim it could be misinterpreted as uncooperative. The reality is that lawful, informed, and respectful exercise of your rights is always your strongest defense. Now here's a final question for you. Which of these 5 legal moves do you think would be the hardest to use under pressure? Share your answer in the comments. I want to hear your thoughts. Remember, knowing your rights is not just about avoiding trouble. It's about being empowered, informed, and prepared. If you found this breakdown helpful and want more real-world legal insights, make sure to subscribe to the channel, press the bell icon so you never miss an update, and let us know in the comments what topic you want us to cover next. Stay smart, stay safe, and always exercise your rights responsibly. Imagine this. You're driving home, the traffic light turns red, and suddenly a police officer is at your window. He leans in and says, "I smell marijuana." Your heart races. Questions flood your mind, and every second feels critical. This is not just a routine stop. It's a moment where knowing your rights can literally change the outcome. But here's the question. Which single action could protect you the most in this situation? Let me know your answer in the comments below. According to official reports and court rulings, officers sometimes claim they smell marijuana to establish probable cause for a search. The law recognizes the odor as potential evidence, but it's not an automatic green light for them to search your vehicle without your consent or other corroborating factors. The Fourth Amendment clearly protects against unreasonable searches and seizures, and courts would likely examine the totality of circumstances, the driver's behavior, the context of the stop, and the officer's observations. First, remember, you have the right to remain silent beyond providing your license, registration, and proof of insurance. Anything you say can be used in court, so keeping your words measured is crucial. One interpretation in legal analyses is that remaining silent while respectfully complying with identification requests preserves your rights without escalating the encounter. Another perspective raised in court is that voluntary statements beyond what's required can inadvertently give probable cause to officers. Second, you can refuse consent to a search, even if the officer insists or tries to pressure you. Clearly saying, "I do not consent to a search," matters legally. In my legal analysis, this simple verbal declaration can make a big difference if evidence from an unwarranted search is later challenged in court. Courts often weigh whether consent was clearly given, and your explicit non-consent is part of that record. Third, staying calm and consistent is essential. Emotional reactions, panic, sudden movements, or arguing can be misinterpreted as suspicious behavior. According to case studies, drivers who maintain a respectful and controlled demeanor are more likely to avoid escalation. Your goal is to assert your rights without confrontation. The fourth legal move is understanding the limits of searches. The odor of marijuana alone doesn't always justify a search. Officers need probable cause, which could include additional evidence, context, or observed behavior. Documenting that you clearly refused consent strengthens your legal position. This is for informational purposes and not legal advice, but practical experience shows that clarity and consistency help protect your rights. Fifth, document everything immediately after the stop. Write down the officer's words, your responses, and the sequence of events. In my legal analysis, contemporaneous notes or recordings can be pivotal if the case proceeds to court. Courts often give significant weight to detailed recollections made soon after the incident. Real-world cases confirm that accurate documentation can prevent misinterpretation of events. When combined, these 5 legal moves, remaining silent beyond required identification, refusing consent to searches, staying calm and consistent, understanding search limits, and documenting everything, create a powerful defense during any traffic stop. Supporters argue that this approach upholds constitutional rights and empowers drivers, while critics might claim it risks appearing uncooperative. In reality, being informed, respectful, and assertive about your legal rights is the best way to navigate these high-pressure situations. Now here's a final question for you. Which of these 5 legal moves do you think would be the hardest to remember and use under stress? Share your thoughts in the comments. I want to hear your experiences. Knowing your rights isn't just about avoiding trouble. It's about empowerment, preparation, and safety. If you found this video helpful and want more real-world legal insights, make sure to subscribe to the channel. Press the bell icon to never miss an update. And tell us in the comments what topic you want us to cover next. Stay informed, stay safe, and always exercise your rights responsibly.